Thank you, everyone. Thank you for the opportunity, gentlemen. I really appreciate it. My name is Ellen Belding, and I'm the owner of SRS. SRS is a 100% woman-owned business. We are union, and we perform concrete and masonry work. Last year, I had 30 people on my payroll. I provide opportunities to people that maybe others would not. We had women apprentices, minority apprentices, service-disabled veterans. I went to an outreach program Thursday, and there'll be another one next week. We believe in doing the right thing, and I've had the fortunate opportunity to have a 30-year career in construction. Before I opened my business 5 years ago, I was a safety and risk management consultant for 3 large contractors based out of Rochester. However, one was a national contractor as well, so I was responsible for labor in 12 different states. So I feel I have somewhat of a history. And I've worked with these gentlemen. I've been participant in the AGC Safety Committee as well as other groups. I'm a member of the National Safety Society, and we have known and recognized for many years that construction is a risky business. There is no question of it. However, since 150 years ago, we have evolved dramatically. The safety, the technology, the things put in place, OSHA, loss control. We know that our employees are our assets. Without our employees, we cannot survive or thrive. Unfortunately for me, as being a small woman-owned business, I have not been able to evolve into a large premium capacity. And with the results of the 240, the Scaffold Law, without being able to defend myself or my position, I'm eliminated the opportunity from obtaining insurance. I've been in business, this is my 6th year. I've never had a general liability accident. I'm very proud to say my comp record is impeccable. However, the insurance carriers realize and recognize as a masonry contractor with the Scaffold Law that I am a risk to them regardless. And they looked at my equipment list this year and they saw a scaffold on it, 6-foot Baker scaffold. And I have been to 5 carriers so far. I'm on an extension, and in 17 business days, SRS will be out of business. I will close my doors if I don't have the coverage. 30 people will lose their jobs. Veterans and minorities and women who are not given opportunities in other companies will be on the streets looking for work. And it is a direct result of the inability of myself and my carriers to bring up comparative negligence during a 240 claim. And I think I bring a little bit more to this other than my personal story right now, which may seem somewhat selfish, but I've been doing this for 30 years. I've represented some of the largest contractors in the state. And I can tell you my primary focus was the litigation, and it was the safety, and it was ensuring that when people come to work, they leave in the same condition as they return. We knew this was going to happen. We knew it was going to be a crisis. We understand that the insurance carriers cannot take on the risk for a premium that will never cover the losses. From a moral perspective, I can tell you that I've participated in probably 15 Scaffold Law cases, personally, providing testimony and or defending them. And it's very, very difficult for me to comprehend that culpability is not brought into play when an employee doesn't follow the rules, doesn't utilize the equipment that's provided to them, or maybe exaggerate some of the claim position, that never can go. The only opportunity that I've had in defending these claims is the amount of damages. One of the things that I don't hear too often, I think it's very, very important, this law was enacted, as I said, before OSHA, but it was also before workers' compensation. And workers' compensation was put in place to be a sole remedy when an injured worker needs to recover. My greatest reward is if people are injured, regardless of the seriousness, regardless of how it happened, is to work with them, provide management, and bring them back into the work environment with their peers and utilizing their skills and their trade that we need in this industry. That's been taken away from me in these claims. And it's taken away from the people who actually are injured, because many times they could come back to work. They could take a revised position. And eliminating the opportunity to bring this forward is an injustice. It's an injustice to society, it's an injustice to New York State, and right now, it is a very personal injustice to me, because as a minority, woman-owned business that is providing jobs in this state, I have 17 days, I'm on an extension now, and if I don't have insurance coverage, it has nothing to do with my performance or capability. It has to do that we can't get a bill for reform out on the floor to be voted on by our legislatures that we entrusted to protect everyone's rights and everyone's needs. I've been on the phone with Lieutenant Governor Duffy. He's working diligently with me, trying to come up with something, an alternative. What can we do? The clock is ticking, and I know he's very sympathetic to it. I don't know what it takes. I've been lobbying here for over 20 years. I've been lobbying for the cause because I believe in it. Now I'm lobbying for me. Please convince the legislators that this bill needs to go to the floor and it needs to be voted on for the rights of everyone. Thank you.